Yeah. Well, welcome everyone. Thank you for joining us. My name is Ryan Reetz, and together with my co-chair, Carole Silver, who's sitting in Chicago, we're very pleased to present this tremendous panel on an inside view of attorney board certification in the U.S. Just a brief introduction before we introduce our panelists. But as many of you know, board certification is typically done at the state level under state bar rules. And today we've got a great panel from several of our 50 states to talk about board certification, how it works, and a number of the intricacies involved. First, I wanted to give just a little bit of a pitch for the benefits of board certification. I'm hoping that people on the call will correct and supplement, revise and extend my remarks. But board certification allows lawyers to demonstrate that they've achieved a particular level of knowledge and experience in a particular field. It's considered a mark of distinction. In Florida, we talk about it as a gold standard for practice. Board certified lawyers, consistent with state bar rules, can typically represent themselves as specialists or experts, depending on what the rules allow. Being board certified really encourages and kind of requires lawyers to maintain their skills in the field, both in practical experience and in continuing education in the field. And the thought is that it may help you get hired by clients. According to the Florida Bar, the belief is that being board certified may increase by somewhere between 25 and 40% of the likelihood that a lawyer is hired by a client. I haven't tested that out myself, but it sounds good. Of course, for clients, board certification lets clients know that the lawyer has a certain degree of knowledge and experience in the field, and it often allows clients to more easily identify specialists in the field. A lot of the state bar websites let you search by board certification, for example. And so that's sort of an overview of why people who haven't yet pursued it might be interested in doing so. I should also mention that although not among our speakers today, the ABA has a standing committee on specialization. It does two main things. It accredits certain specialty accreditation programs, and it also serves as a tremendous resource for information on board certification. So if that's something that's of interest to you, the ABA Standing Committee on Board Certification is really helpful. That being said, I wanted to introduce our panelists for today. We have Gary Davidson sitting on my right from Diaz Reus here in Miami. Among other things, Gary was an inaugural member and is the former chair of the Florida Bar's Certification Committee for International Litigation and Arbitration. We have all the way from Texas, Leo Figueroa, who's the executive director of the Texas Board of Legal Specialization. We have from California, George Shermitis from his own firm, who is the chair of California's Board of Legal Specialization. And from Louisiana, we have Marianne Wegman, who's the specialization director at the Louisiana Board of Legal Specialization. So we want to pepper you all with questions, but hopefully you'll go beyond our questions and help us get an overview of how the process works in your respective states. And hopefully we'll get some questions from people on the line as well. But I guess for each of you, we wanted to ask if you could please just give us sort of a brief overview of the board certification programs in your respective states, when it started, how many areas it covers, how the programs are administered, by whom, that sort of thing. Maybe we could start in California with George.
Sure. Well, California, I believe our program is the oldest in the country. It began in 1973, and it's continued since that time, although it's evolved in different ways. It's primarily overseen by the State Bar of California Board of Trustees. The State Supreme Court of California had directed the State Bar to administer the program, but it's overseen by the Board of Trustees, and then below that, us, the Board of Legal Specialization. One thing in California that might differ from some other states is that the State Bar here is a true regulatory agency. I think it's close to a consumer protection agency. And it's separate from the California Lawyers Association, which split off about a decade ago. So the California Lawyers Association is more, I think, what we see in some states as a bar association. But this is a true regulatory agency overseeing us. And so because of that, that drives some of our decision making, especially in terms of how we look at specialty areas, creating new specialty areas, and what types of outreach that we want to make. Things that we look at, for example, are a justice gap study that was commissioned by the State Bar a few years ago, which looked at underserved populations, what areas consumers need, and how we can meet that. And so that plays a role in how we look at practice areas. California has a total of 22 specialty areas. 11 of these are offered directly through the State Bar. And I don't know if we want to show a list of those. And then we also allow certain accredited entities. So these could be other organizations outside of the State Bar of California, and they have their own testing and qualifications, but it has to be in one of the external accreditation areas. So we both have the direct practice areas that we offer and test on, and then also external entities in these additional areas like Social Security, disability law. And that allows us to provide a greater breadth of specialization. In California, to become board specialized, a person has to submit an application. They have to show a number of years of experience, completion of task requirements, such as number of trials, depositions, depending on the specialty area. We have to have peer evaluations, usually by other attorneys and judges, and also undergo testing. Every 3 years, we submit our CLEs every 3 years alphabetically, and certified specialists in California have to submit a separate compliance card every 3 years, showing 36 credit hours in that specialization area. That's in addition to 10 additional areas required in areas like reducing bias in the legal profession. So we do have a special education requirement, and it's higher than what a non-specialized attorney would submit. Every 5 years, we have to be recertified to show that the person's continued in the task requirements, that they're meeting all the standards. So that's kind of a rundown of how California works.
Perfect. Thank you. Gary, you want to tell us about Florida?
Sure. Florida has long had certification in a number of areas, some of them extraordinarily specialized, others more general, or might be viewed as more general. I am personally certified, as is Ryan Reetz, in International Litigation and Arbitration, which is, if not the newest, one of the newest certification programs that was started about 6 years ago. It's a process to create a certification program. It's a long and arduous process, as was the case with International Litigation and Arbitration. We were preceded by international law, which is a specialized program in other states, for example, I believe in New York. Nobody in the United States had ever come up with the concept of creating international litigation and arbitration as a separate specialization. The reason it came about was because the international law concept was so broad and encompassed so many different topics that those who were involved in the international law section were complaining about the fact that many of these topics in international law, while they would be things you would want to know, would not necessarily be things you needed to know to be certified in a program such as international litigation and arbitration. And so we moved in a direction of having both the international law certification, which preceded us, and this new program, international litigation and arbitration. That process, and I hope it doesn't ever take this long for any other state, took close to 10 years to bring to fruition for a lot of reasons I won't go into. But in any event, each of the board certification programs is able to adopt on their own certain requirements that other specializations, for example, might not have. So in the case of international litigation and arbitration, obviously we wanted people who had experience doing the work, doing not just international litigation and arbitration, but being able to show that the various components of that program were actually touched upon by the applicant. So, for example, there's a trial requirement. There's a motion practice requirement, and a motion practice requirement that includes substantive issues such as that might arise in summary judgment. Other certification programs don't have that sort of requirement because their certification, for example, aviation law, aviation law as a practical matter, in many cases is predominantly regulatory. So yes, there are people out there who practice in aviation law who do litigation and arbitration, but the components and the requirements of that particular program are very different from, say, for international litigation and arbitration. So that within the sort of the umbrella of the Florida bar, you have a broad variety of certification areas, the qualifications for which vary to a certain extent based upon and tailored to that particular program.
And I should just add maybe that the various certification areas are all administered under the umbrella of the Florida Bar's Board of Legal Specialization and Education, BLSE, to whom we periodically answer. Marianne, could you please tell us how it works in Louisiana?
Well, we're a lot smaller than California and Florida for sure. We have 9 specializations. We've been around since 1993. Louisiana Supreme Court created Louisiana Board of Legal Specialization 33 years ago. Right now, we have approximately 400 board certified specialists. I don't think, how many are in Florida? I didn't hear, or in California, about approximately how many, do you know how many board certified specialists do you have at this time?
In California, in 2025, we had 4,641, and those were primarily in estate planning, trust and probate, and family law. Those are the biggest areas.
Right.
And in Florida, we're around 5,000, I think. Not so many in the certification area that Gary mentioned, more in sort of trial practice, real estate, that sort of thing.
So yeah, we're similar to California because most of our specialists are in tax law, estate planning, and family law. So that seems to be the most prevalent. So we have so the requirements for specialization for us are you have to practice at least 5 years full time. That's a major thing. You have to be a full-time practitioner. And then you have to be a member in good standing of the Bar Association. In Louisiana, we have a mandatory bar. So you must be a member of the Bar Association. You should have to show substantial involvement in your field of law, which the way we look at it, the 48 of the last 60 months prior to your application year, you have to practice in that area, like 25 to 35% of your practice has to be in the specialization. You have to pass the written exam. So we offer both take-home exams and we offer it virtual, monitored on Zoom. So both ways work very well for us. And then we do have peer review. You have to submit 5 references, favorable, and one should be from another board certified specialist in your specialization. So some of our specializations are relatively new, so there's not as many specialists in. So if that's the situation, some of them waive that requirement of having one from a board certified specialist, because we're trying to get specialists from around the state, and a lot of the specialists tend to be more concentrated in the New Orleans and Baton Rouge area. So they've worked on that. And then you have to show proof of professional liability insurance, which is a major deal. So most specializations require $1 million and some couple of 500,000, but most of them really, $1 million. So and then the dues, so it's an application fee. I think you'd asked about that. It's $400 to apply, and then once you're accepted or you pass the exam, and then there's another $150 certification fee to get your certificate. So we have calligraphy, they're hand engraved certificates, and people really enjoy the personal certificates, so we do that. And then we also do the recertification. We do that every 5 years. So as part of our recertification program, we publish the names of the attorneys up for recertification and in the Bar Journal, and request any comments or concerns, and as part of our recertification review. So, and then with the CLE, so we do it every year. So most 2 of the specializations, tax law and estate planning, require 18 hours of approved credit, CLE credit in that particular specialization. The way we do it, we have CLE committees for each specialization, and when the sponsor puts up wants to have a CLE approved for specialization credit, they submit the paperwork, and then the CLE committee reviews it, either approves it or doesn't. And then we have an approved course calendar on our website, so anybody can go to that website and pull up their specialization to see what's been approved, and that way they know they can take that course and they'll automatically get credit for it. But in Louisiana, the Supreme Court rule, only 4 hours can be online, the remaining hours have to be in person. So that's a big deal. So there's a lot of in-person CLEs in Louisiana to satisfy that. So
Excellent. Thank you. But before, I should turn it over to Carole in just a minute, but before that, Leo, could you please tell us how it works in Texas?
You bet. We are a very old organization, a year younger than California. We were created in 1974 by the Supreme Court of Texas. Our first 3 specialty areas were in criminal law, family law, and labor law. And as of today, we have 28 attorney specialty areas. Within the last 10 years, we've added 7 attorney specialty areas. Even though we are affiliated with the State Bar of Texas, we are under the jurisdiction of the Supreme Court of Texas. We've got a 12-member board of directors, so they oversee the TBLS program. And with respect to each of our 28 specialty areas, we've got advisory commissions for each of those 28 specialty areas that reviews applicants and makes a determination whether they should be recommended to sit for the exam or not. And ultimately, those recommendations go to the TBLS board that makes the final determination. We've got, with respect to all of the 28 specialty areas, we've got exam commissions for each of those specialty areas that drafts the exams, grades the essays, and makes any changes to the respective exam specifications. In terms of the criteria for someone to get approved, number one, they have to be a member in good standing of the State Bar of Texas. They have to have been practicing law full-time for 5 years. They have to have met the minimum substantial involvement percentage in the specialty area in the 3 years immediately preceding application. And in the 3 years immediately preceding application, they have to have amassed at least 60 hours of CLE in the specialty area. In terms of how the applications, what do we look at? We, of course, look at whether or not they meet the specific task requirements for the specialty area. For example, if it's the criminal law, the number of felony jury trials, misdemeanor jury trials, federal jury trials, federal appeals, so on and so forth. We do a peer review as well, looking at references, get references from judges before whom an applicant has appeared. So we look at all of that. And then we also look at whether they've had any disciplinary actions in the past, whether it's private reprimands, public reprimands, sanctions from a court. All of that is considered by the advisory commissions in making the recommendations. To apply, our application fee is $250. And once you are approved, there's a $350 exam fee. Assuming an applicant passes the exam, they are required to submit annual reporting every year to TBLS as verifying that they are meeting the minimum substantial involvement percentage. They are required to advise us within 30 days of receiving any disciplinary actions from a court or from any organization, whether it be the chief disciplinary counsel's office or otherwise. Lawyers must get recertified every 5th year. And that recertification, we naturally look at any disclosure of conduct, disciplinary proceedings they may have had. We submit or solicit references. In most instances, with most of the specialty areas, we look with respect to the references, those are references supplied by the applicant, but TBLS also will choose references either from the geographic area that the applicant's from or from the cases listed as opposing counsel. With respect to judicial, we also certified judges since 2025. And this was a first for TBLS. The Texas legislature, in their infinite wisdom, decided they would, for the first time, order the Supreme Court and TBLS to create a specialty area in judicial administration. And that's exactly what we did. And the judges that are applying for certification in judicial administration, they do not submit references. TBLS selects the references on our own without any input from the applicants. And I think that about covers it, unless you have any questions.
That's great. Thanks, Carole.
Very interesting. So, if I'm not mistaken, at least in some of the states, certification started just before advertising was allowed, right? And so I'm curious about how certification kind of dovetails with other issues that the bar or the Supreme Court of the state oversees, like malpractice, and whether you've found that lawyers who are certified are less likely to be found liable or be sued for malpractice or for violating the bar rules. What else do I have? I'm also just curious about the percentage of lawyers in your states who have a certification. And because it seems like, gosh, it'd almost be a no-brainer. If you get to a certain level, wouldn't everybody want that? Because the people you're competing with have the certification. So then if you don't, assuming that the public at large kind of knows that this exists, it would look bad, right? What do you think?
And let me take a stab at that. A lot depends on the specialty area involved. In terms of a percentage of the Texas bar, it's between 6 and 6.5%
Hmm.
are board certified. But when I mentioned that it depends on the specialty area, for example, in family law, and that's the specialty area that we always have the greatest number of applicants, the greatest number of examinees. And part of the reason for that is if you're board certified in family law, guess what? You get to charge higher hourly fee, and you get a lot more referrals. So it's like a self-perpetuating we don't have to do any advertising. I mean, for example, the state bar puts on various CLEs in various areas, and the one area that always has the most attendees is family law. So it's just ingrained. Let me mention one other area, labor and employment law. Most certified labor and employment lawyers, you probably aren't surprised by this, are on the defense side. And they're members of firms that represent management in labor and employment matters. And it's an unwritten rule, or perhaps it is a written rule in some firms. If after you've been there for so long, you'd better get your board certification in labor and employment law. And companies, management, when they're looking for a lawyer to represent them with respect to drafting a handbook, dealing with non-competes, being sued for Title VII discrimination, they want a board certified labor and employment lawyer.
Mm. George, how does it compare? How does that compare to what you have in California?
Well, the same thing. Certain areas have more certified specialists, like family law, and I think for some of the same reasons. And also, I think consumers are more sensitive in family law in terms of who they choose. I'm a certified specialist in workers' compensation law, and we actually have over 900 specialists in that area.
Is that a lot? I don't have a sense of what that means.
Not compared to the statewide number of attorneys. I don't know the statistics on the number of workers' comp attorneys, but there are a lot in California. I think it's a small percentage. And what I hear from other attorneys, because I've looked at this, is, oh, I don't want to do that because I'm held to a higher standard of care. They think that they're more likely to be sued. And I'm not aware of any statistics on that. Also, I don't think consumers are as aware of specialists and what it means. And I think that's an issue. And those are things we're working on.
Do you put some like seal of approval indicating the specialization on your bio on your website or?
Yes, we have actually seals from the state bar that we can put on our website and so on. I don't think consumers are as aware, but there's a quirk in California law. I don't know about other states, but in a workers' compensation deposition, the other side pays our attorney fees during the deposition. And the current trend is to allow certified specialists to charge a higher rate, which makes sense. And so I think that'll create some incentive for it. But I think there's fear about it. Also, it costs more. The CLE credits are a lot higher.
Oh, they are? It
Yeah,
costs more to do the CLE? Oh.
The certifying as a specialist, recertifying and so on, has additional fees and costs. And I think a lot of attorneys just don't want to go through that.
Yeah. Yeah.
You know?
Is anyone ever certified in multiple areas?
Yes, not a large number. but there are some. I recently spoke to an attorney who was dual certified in taxation law and estate planning. And there are, but not a huge number.
I can jump in on that. We've got almost 900 lawyers that are certified in more than one specialty area. And I can tell you from personal experience, although my certifications are inactive, I was board certified by TBLS in civil trial law and personal injury trial law, which I received back in the dark ages, but I'm on inactive status now since I'm no longer representing clients. But we've got a good number that are board certified in multiple areas.
So I have another question. Do you ever kind of review the subject matters and conclude this just isn't hitting the mark, this subject matter, and we don't need it anymore, and so you get rid of it?
We had that issue recently with admiralty law because we had, I'm not sure how many years, but where no one was taking the exam. And a fairly small number of admiralty law practitioners. And what we decided to do was to stop new applications, but allow persons already certified to keep their specialization. But we've also looked at, and so we started to do an annual review of the areas to see if is this cost effective? Is there enough interest in it? And we've also are expanding areas. We just approved, and in the State Bar of California Board of Trustees just approved a privacy law specialty. That took 5 years to develop. And we're looking at both personal injury and consumer law now as new areas. Surprisingly, we haven't had personal injury law especially.
Do you find that I'm going to stop after this, Brian. Do you find that that there's that most of the people who pursue certification are in certain practice settings, so in smaller firms versus large or national firms, or you could be in-house? I guess you could be a government lawyer. Are there certain practice areas that dominate or no?
Probably large firms dominate probably in Louisiana, but we have government lawyers, we have, in-house counsel, for, small. But the exam is a consideration for a lot of practicing attorneys. They don't want to take the exam, and I guess I hear that's the most discouragement. They don't want to take the exam, so they would love to do specials, but they don't want to take the time because the exam is, no cakewalk, and you really have to put some time and effort into it. And so it's just, with their practice and all, a lot of people say they just don't have the time to do it. So that's one reason why you don't have specialists, because of the exam.
I should have asked, what's the pass rate?
It just every year is different, we don't disclose that either, but yeah, it's, so.
Yeah, one of the biggest challenges in recruiting people to which we do as existing board certified members, that one of the problems in recruiting people is it is a huge project to launch. The background paperwork that you have to, I compare it to, it's not quite as bad as your initial application to become a member of the Florida State Bar. But the amount of, background information you have to provide, you have to recruit your referees, which isn't a really big deal. But then if you're going to have to take an exam, you have to study for the exam. So you have to be dedicated, and I think that in the absence of a firm's pressure on an individual or group of individuals to do it, it's very easy to just say, this is just too much work. And that's number one. Number two, the other nuance that we encounter occasionally is, and particularly in the narrower specialties like international litigation and arbitration, many of our colleagues who could be certified say to us, well, I do a lot of domestic work as well as international litigation and arbitration. I don't want to be pigeonholed by potential clients. Oh, we don't want to hire that. They just do international work. That's their principal focus. And so there's that sort of tension with certain certifications that you're becoming too specialized. And if you have a more general practice, you are potentially alienating customers or clients from coming to you. I don't buy into that theory. I see it as additive, certification as additive, not as detracting from attracting other clients for other reasons.
It's super interesting. As you can tell, I knew nothing about this until this panel. So I'm really grateful to you for your expertise, for being here. I think Shadman, you had a question. Do you want to ask it now, and then we'll keep going?
No, I can wait till the end. I had just some question with the continuing education.
Okay. Okay, Bryan, back to you.
Okay, sure. Well, we've heard from California and Florida a little bit about new certification areas, not so new in our case. But I wondered about the process for creating a new certification area. And maybe we could go sort of in reverse state alphabetical order. So we get to Florida and California last. But Leo, is there a process in Texas for doing this, and how would it work?
Yes, we've got an application process. Usually new areas, a request to recognize a new specialty area comes from the sections of the State Bar of Texas. And ordinarily that group will get together. They've got to get at least 100 attorneys to sign a petition for recognition of the new specialty area. Among those 100 attorneys, a certain number have to volunteer to be on the advisory commission. A certain number have to volunteer to be on the exam commission if it's recognized. And most importantly, they have to provide a detailed rationale, reasoning why it's in the public interest to recognize the new specialty area. They have to submit proposed standards that are specifically tailored to the specialty area, and have to submit proposed exam specifications along with that as well. And they also have to address whether or not there's any conflict with existing specialty areas. And so, I mean, that's a process. And once that's done, the TBLS board looks at it, makes a determination whether or not to pursue it. Oftentimes, the first step will be submitting the proposed new specialty area for public comment. We submit that to various sections of the bar, as well as various members that are board certified in related specialty areas. Once those public comments come back, then the board decides at that point whether to continue pursuing recognition of the new specialty area, possibly with revisions to the proposed specific area requirements for the specialty area. And then it is submitted ultimately to the Texas Supreme Court, which makes the final determination whether or not to recognize the new specialty area. And that's not a done deal. There's been instances where a proposed specialty area is submitted to them, and they decided, no, we're not going to do that. But they have the ultimate decision making in that.
Interesting. And Marianne, I think I saw on the Louisiana webpage that you all have an established process as well for new areas.
Yes, we do. And we pretty much track Texas. However, ours is on a smaller scale. It's only 20 lawyers that have to sign, but it comes usually from the sections, from the Louisiana State Bar Association sections. And there is an international law section of LSBA I know you were asking about something about that, and I said, and since the section has proposed rules to allow foreign consultants to practice on a limited basis in Louisiana in the law of the country of their origin. So that appears on the website, but none of them have indicated any interest in having a specialization. But instead of going, like we pretty much the same format as Texas. However, ours goes to the House of Delegates of the Louisiana State Bar Association, and then they recommend to the Supreme Court whether it should be approved or not. But we have had two specializations that came through this channel, which was appellate practice and health law. And so it really just takes one person who's really wants it, and they kind of push it through. So it's motivation. But I have had inquiries about privacy law, and I know it's interesting. California's demos, they just had privacy law added to a specialization. So we have had inquiries. So that seems to be a bubbling up area that would be privacy law.
That's great. Speaking of one person who really wants it, Gary, if it doesn't stress you out too much, can you tell us a little bit about the experience with starting the new certification in Florida for international litigation and arbitration?
Sure. The genesis of this I mentioned earlier, and that was that we had an international law certification program, which was somewhat unique. Not many states had it. That covered a number of different topics, which really people such as myself who do international litigation and arbitration would rarely encounter. So the feeling was amongst those of us who were litigators and arbitration inclined was we needed our own specialty. And as I said, it was about a 10-year process, and it was painful, to say the least, because what started as we can do this in the international law section among those of us who were, active practitioners in the area, none of us realized the depth of how far we'd have to go in convincing groups of the Florida bar, sort of the layers of groups of the Florida bar at each hierarchical level, and each of those groups having the ability to tell us, well, why don't you do it this way and not that way? And it was just mind-numbing. At one point, they said to us, one of the specialization boards said to us, well, you know what? We don't think you should have a separate program for international litigation and arbitration. Why don't you just add it to the existing international law one so people could decide, okay, I want to be certified in international litigation and arbitration, or I want to be certified in international law, but it would all be under the same umbrella. So we then had to redevelop the concept as if we were not going to do a specialized standalone program, only to be told after we did that and went back to the Board of Legal Specialization and said, well, there's no reason for you to do it that way. Why don't you have a separate program? And so we went back to the drawing board, came back with a new proposal along those lines, very much like the first proposal. And then we had somebody on the Board of Legal Specialization who was specialized in business litigation. That gentleman said to us, well, you don't have a component of your application process where your applicants have to show that they have done certain levels of activity in the litigation and arbitration arena, in front of arbitral panels, in front of judges, doing trials, etc. So we went back to the drawing board, added those components in, and finally, after that was done, we were approved by the Board of Legal Specialization, went up to the Board of Governors, which approved the program, went to the Supreme Court of Florida, which approved the program. So that's why it took 10 years. Not to say the least, I think after year 3, it just got to the point where it was just like, no, this is going to happen no matter what. However long this takes, and it was clear it was not going to be a quick fix. We're going to get this done because that's how we roll in this group of people who were, trying to promote this program for the Florida bar.
Yeah, I think it's fair to say we learned a lot of lessons along the way, and if there were to be a new certification area being proposed, we could probably help those people a lot in Florida with the process.
For sure.
And we did have a happy end to the story at the end of the day.
Yes, we did.
But I hear you. Sounds like the California experience with the privacy law certification was maybe a little smoother. George, could you tell us about that?
It actually was a lot of work. It started with a application by the California Lawyers Association privacy consulting group. So they submitted an application to us with an outline or answering just different questions about the cost, the likely number of people to take the exam, and the interest. And that moved forward. The consulting group continued to develop the standards, including the testing, what would be on the test, the type of experience required, the standards, and it was extremely detailed. And I think took many, many hours of work. And then they presented to us more than once. And going through that, we ultimately approved it, and then it went up to the State Bar Board of Trustees for approval. But that process took 5 years. It's a lot of work to develop a new specialty. And also we have to look at whether is this something there's a real interest in. Is it going to be cost effective? It's expensive to run a specialty. It's expensive to develop the tests and provide them. And all of that has to be weighed, as well as, us looking more towards now or trying to be guided by the justice gap studies, trying to meet underserved populations, as well as protecting the public. I think it's a very arduous process.
I feel oddly comforted by that. Maybe we should turn to Shaban's question and then kick it back to Carole. Shaban, is now a good time to ask?
Yes. Hi everyone. Good afternoon. I have one question for continuing education on law. So, first of all, I would like to give a short introduction about me. It's my first time meeting you all. So my name is Shadman Khan. I have passed my Bachelor in Science degree from one of the New York State universities in Science and Technology background, and I would like to move forward on a continuing education with Science and Tech Law now. So I'm wondering if I get CLE credit, and if I certified in a specific thing in any category of Science and Tech Law. Will I be able to practice law as a paralegal?
If anyone wants to jump in, please feel free. I mean, my initial guess would be that this is a state-by-state issue, but that to work as a paralegal is something that you can generally do without having a law degree, of course. And it's a question of seeing whether there's any requirements in the state where you want to work as a paralegal and qualifying for them. To practice law as a lawyer, it generally involves, the law degree. And then if you want to be a specialist lawyer, a board certified lawyer, then you have all the additional requirements we've been talking about. But with a college degree and a lot of supplementary education like you're talking about, you would probably just be looking at whether you would want to have a paralegal certificate or something like that in the state where you wanted to work. Anyone else, please feel free to correct or supplement that. Right. So I guess that's the long version of the short answer. Does that help?
Yeah. Yeah, so the reason is to continue my education because I have the education background behind the science and tech. So I know um, the tricks, trends, and tactics of all behind working in science tech law. So that's why I was wondering like if I can like switch my career into the science tech law, that would be awesome. And that's why I was wondering what would be a best suggestion for me to consider right now if I can have a Juris Doctor degree or like take CLE credits or take certification to practice law and science and tech right now.
Don't think it, at least in the jurisdictions that I'm familiar with, you'd have to qualify as a lawyer before you can actually practice law, regardless of training in technology. And to do that in most jurisdictions, but not all, you have to get a JD degree, a 3-year JD degree. It's just that's the basic law degree. But there are some jurisdictions where you don't have to. California's one of them, I think. I don't know if you want to speak to that, George, or not.
You would have to be a licensed attorney in California. There are some kind of twists in the law. For example, in workers' compensation, there's a specific regulation that allows a non-attorney to do a lot of things, talk to clients, appear at hearings, perform depositions under the supervision of an attorney. That's the only exception I'm aware of.
The only thing I wanted to mention is that there are now master's level degrees offered by some law schools in certain fields, including technology. They don't qualify you to practice law, but they do give you some legal information, legal knowledge, so that you can work if you want to. The idea is to work in the legal field, but not as a lawyer. So if you wanted to work as a lawyer, your path is generally to law school. So I wanted to pick up on this grueling process that you all are describing to get a certification, to get to certification. And you all have a lot of experience with this. So I wonder, looking back on your experience and kind of broadly, what would you change to make, or would you change something to simplify the process, to make it more streamlined, or make it a little easier to create a new certification? Or maybe there's enough justification for making it difficult that you wouldn't change anything.
I think for us, we want to look more at the external groups, the areas that could be certified by external organizations that take some of the work off our program staff. That's one way. We have looked at ways to make the process more efficient. I think in the past, we were less proactive and would receive applications from certain groups. Now we're more proactive in doing an annual review as to what can we change? Maybe what do we want to add? The process itself, though, I think it requires a lot of careful consideration because it's kind of hard to unwind once you do it.
Yeah, yeah.
Um,
Anyone else?
Yeah, I mean, I passed some theory credits and I passed some theory credits from you, and I was wondering if I can like provide any like if someone like seek any legal advice or anyone like if I can like provide legal advice or consultancy um like in my background to someone like having those theory credits.
Maybe a good way would be if you want to stay on the call at the end of our session, I can maybe try to guide you to someone who could answer that question. So I think we might not be the best people to help you with that, but I can hopefully point you in the right direction. Does that work for you? Just hang on the line after we wrap up?
Yeah.
Fantastic. Thanks.
Well, I think the only other question I have, and I'm not sure it's a 2-minute question, is what's next in terms of topics for certification? And since Shadman raised the question of technology, and technology is, pretty hot field, is that on the agenda?
Well, clearly, there's going to be a shakeout in the legal practice with the advent of AI and all of the issues that are now coming before investors, lawyers, judges. So I would think a technology-related specialization, which encompassed that as one part of it, might be on the horizon. Maybe not right now, but within the next few years, I would say I would be likely to see at least some states moving in that direction.
Thank you so much. I have to jump off, but I hope you'll go ahead. And I just want to say thank you again to Ryan for organizing and to you for being here and sharing your experience and expertise. Thank you.
Thank you, Carole. Let me just ask, because I'm sure many of you may also have to drop off. Are any last remarks that anyone would like to make before we close? Things we should know about?
The privacy law area in California, I am aware that some of the proposed standards include technologies. I don't know if that would be narrowed into a separate area, but it includes things like AI, autonomous vehicles, robotics, social media. But it probably needs to be narrowed down. AI is such a huge issue.
Good point.
And it might affect the exam process too, AI. So that's another major issue that's been advanced. So.
For sure. Well, I guess we're at a point where I can thank all of you for joining us as panelists and as listeners and questioners. And we can wrap up the session. And thank you once again.
Thank you.
Thank you. Nice to meet all of you.
You too.
Thank you.